Hello, everyone. My name is Ron Wheeler from Boston University School of Law. And you, just in case you don't know where you are in the AALS open source program titled Critical Legal Research, The Next Wave, a panel honoring Richard Delgado and Jean Stefancic. I am going to start out with a few introductory remarks. So I want to begin with a very personal story in the tradition of our honorees. The year, if you can imagine it, is 1987, and some of us remember the 80s, and the location is Ann Arbor, Michigan. After receiving my BA in accounting, of all things, I moved from my family home in Detroit to Ann Arbor to attend the University of Michigan Law School. Me, the Black gay man with the artist formerly known as Prince haircut that came down over one eye. I don't think they were ready for me. I was ready to be inspired, though, to be intellectually challenged, to discover ways of interpreting and applying the law that made sense, that I could apply to my experience growing up in Detroit, to that of my automotive worker father and my clerical worker mother, to that of my grandparents, a custodial worker and a chauffeur. What I found was that nothing seemed relevant to my life experiences. Indeed, everything in and outside of classes served to erase, invalidate, ignore, or dismiss all that I knew was real and truthful, even if ugly and oppressive. Black students told me, "You're not Black, you're gay." Gay students told me, "You're too out. Don't speak to us in the hallways." I was on the verge of dropping out and leaving law school altogether. But for some reason, I returned for the second year and took a course called Black Legal Scholarship taught by a Professor Culp who was visiting from Howard. We read Patricia Williams, and I felt less crazy. I felt seen. Finally, a legal scholar speaking the truth. From her, I moved on to Derek Bell, Mari Matsuda, and our guests, Richard Delgado and Jean Stefancic. And here I am today. So quite literally, I owe my legal career to you, our special guests. Thank you. So really quickly, what is critical race theory? It's crazy to try and define it in front of our guests here, but I will quote from them. Critical race theory is a movement, is a collection of activists and scholars engaged in studying and transforming the relationship among race, racism, and power. It considers many of the same issues that conventional civil rights and ethnic studies discourses take up, but places them in a broader perspective that includes economics, history, group and self-interest and emotions and the unconscious, etc. Unlike traditional civil rights discourse, which stresses incrementalism and step-by-step progress, critical race theory questions the very foundations of the liberal order, including equality theory, legal reasoning, enlightenment, rationalism, and neutral principles of constitutional law. Important scholars to this movement include our special guests, as well as Derek Bell, Patricia Williams, Kimberly Crenshaw, and Mari Matsuda. So now I'm going to briefly try and introduce our special guests. Do they need introduction? Richard Delgado and Jean Stefancic. And I just want to say out loud that it's a little bit of a setup for me to be given the task of introducing our honorees, the fearless, profound, inspiring thinkers, storytellers, scholars, visionaries, and two people whom I count among my personal saviors. Professor Stefancic is a professor of law at the University of Alabama, where she writes about civil rights law, reform, social change, and legal scholarship. She's written and co-authored over 50 articles and 15 books, probably more than that by now, and many with her husband, Richard Delgado, with whom she shared writing residences in Italy. Their book, Critical White Studies, Looking Behind the Mirror, won a Gustavus Myers Outstanding Book Award. And if you haven't read it, you really should. her book How Lawyers Lose Their Way examines how law practice can stifle creativity. Quickly, Richard Delgado teaches civil rights and critical race theory at the University of Alabama School of Law. Earlier, he taught at UCLA and the University of Colorado. He's written and co-authored numerous articles and books, many with his wife, Jean Stefancic. He is a founder of the Critical Race Theory School of Legal Scholarship and is also notable for his scholarship on hate speech and for introducing storytelling into legal scholarship. So, really quickly, what is the triple helix dilemma in legal research? In a 1989 article, Why Do We Tell the Same Stories? Law Reform, Critical Librarianship, and the Triple Helix Dilemma, this article appeared in the Stanford Law Review. And in a nutshell, what it describes is that our classification systems like the Library of Congress subject heading system, the Index of Legal Periodicals and other periodical indexes or other indexes, and the West Digest system, all three are hegemonic forces. And these classification systems replicate pre-existing ideas, thoughts, and approaches, and stifle creativity and innovation. Again, in 2007, an article appeared titled, Why Do We Ask the Same Questions? The Triple Helix Dilemma Revisited, authored by, can you guess? Professors Stefancic and Delgado. It appeared in Law Library Journal, and it's posited that computer-assisted legal research and electronic searching retain many of the constraints attributed to their print predecessors, and that computers, the hoped-for savior from hegemony, only delivered more of the same. And oddly and wonderfully, in a sort of all things come full circle sort of way, in 2011, I wrote an article titled, Does Westlaw Next Really Change Everything? And in that article, I critique what we now know as artificial intelligence and machine learning as applied to research algorithms, just like the one employed in Westlaw Next, and many of the same critiques. Anyway, let's get on to our distinguished panelists. I'm going to let them introduce themselves. Our panel is a panel of emerging critical information scholars that are going to reflect on how the triple helix dilemma has shaped their thinking and continues to be relevant to them today. And first to introduce himself is Nick.
So good morning, all. I'm indeed Nick Stump. I'm the head of reference and access services and a library faculty member at the West Virginia University. And today I will be talking on the intersection of a radical approach to critical legal research and non-reformist reforms. Now, Ron, will I go ahead and launch into my remarks, or are each of us going to introduce ourselves first?
Oh, you're on mute.
Thank you. I knew that was going to happen once or twice during this talk. Go ahead, Nicholas, and then Nick and everyone, just introduce yourselves before you speak, please.
All right. Well, I would like to first echo Ron's thanks to the panel organizers. It's so exciting to have a critical legal research panel in this sort of a national setting. And I too would like to express how honored I am to be on this panel with Professors Stefancic and Delgado, who are certainly two heroes of mine as well, in addition to all of my other wonderful library colleagues from across the country. So I will first briefly outline my approach to critical legal research before I then turn to my topic of the day, which is indeed the intersection of critical legal research and non-reformist reforms. So first, just to briefly outline my approach to critical legal research, which in my most recent article I conceived of vis-a-vis the following four dimensions. So the first dimension is deconstructing the American legal research regime, demonstrating how it does homogenize research outcomes towards hegemonic ends, specifically white patriarchal capitalist hegemonic ends. Second, exploring a more intensive practitioner reliance upon critical theoretical resources in particular through both practice and praxis. Third, centering a bottom-up grassroots approach to lawyering, specifically through more radical variants of community lawyering, and then also Marxist and socialist steeped radical cause lawyering per se, right? So in this instance, it would be essentially a critical legal research influence on those more radical modes of lawyering. And then fourth and finally, focusing on true systemic reformations over intrasystemic law reform or privileging radical social change beyond our current ecological political economy, beyond any sort of classic liberal law reform. So that is my more radical approach to critical legal research in a nutshell. I should say it's based on a synthesis of everyone's work here today on the panel. Again, in addition to additional strains, particularly Marxism and neo-Marxism, and sub-schools such as eco-socialism, ecofeminism, and the Black radical tradition. So my topic of the day specifically is how could a more radical approach to critical legal research, such as this one, support non-reformist reforms, right? Which is a new topic and a new subject for me, which I am excited about exploring in a preliminary sense today and through some related work. So what do I mean by the discourse and practice and praxis of non-reformist reforms? So oftentimes on the left, including on the legal left, right, we have something of a strict binary between classic liberal law reform on the one hand, which we of course tend to eschew as critical legal scholars, and then on the other hand, true systemic reformations, again beyond white patriarchal capitalism, right? We sort of approach that as a strict binary, oftentimes, again, through a more Marxist influence approach, really just focusing on systemic reformation strategies and tactics. So what non-reformist reforms offer, however, I think, is a bit of a missing piece to this puzzle, right? Sort of disrupts that binary of reform on one hand and systemic reformations on the other. It allows us to transcend that binary. And in a nutshell, the idea is that with these non-reformist reforms, if the reforms are carefully conceived, they can, in the end, help us better achieve those true systemic reformations. And again, it's there's a longer tradition of non-reformist reforms, but Professor Amna Akbar at Ohio State in particular has done some really exciting work on the legal left recently, exploring this concept. And so it's her approach that in her summary in a recent piece that informs a lot of how I've thought about non-reformist reforms to date. And briefly, I think there's at least two dimensions to them that I think are worth mentioning in a condensed panel format. Right. So two aspects of non-reformist reforms that differentiate them from classic law reform. The first is that non-reformist reforms do not accept the existing liberal capitalist paradigm. Right. The explicit idea of the reforms is that they will ultimately serve to undermine the current white patriarchal capitalist system and bring us to an emancipatory alternative, which may be something like eco-socialism, materialist Marxist, eco-feminism, among other strains on the left. So that's one dimension. A second is that certainly non-reformist reforms are not elite change agent focused, right? They don't privilege elites, such as attorneys or other institutional elites. Instead, the idea of non-reformist reforms is that we are indeed building people power. We're empowering grassroots social movements to self-organize themselves, to empower themselves, to ultimately pursue, again, that more transformative change. So in closing, the question of how critical legal research might support non-reformist reforms, again, it's a newer topic for me, so it's something of an open question. I'd be thrilled to hear what our other panelists, Professors Stefancic and Delgado might think. But I do think there is great potential for a radical approach to critical legal research to support them, to support these non-reformist reforms. In particular, I think CLR, or critical legal research infused radical community lawyering and again, Marxist and socialist steeped radical cause lawyering, right? I do think that those lawyering modes where lawyers fundamentally support social movements and don't drive the social change process and support them, I think it's one way in which critical legal research through the research dimension can help support non-reformist reforms, again, hopefully bring us towards a more emancipatory future. So for me, thank you.
Thank you, Nick. That is great. That gives us something meaty to chew on. Next, Yasmin.
Hi everyone. I'm going to go ahead and share my PowerPoint. Make sure that is up there before I begin. All right, everyone can see that. Great. Okay. Hi everyone. I'm Yasmin Sokar Harker. I am a reference librarian and law library professor at CUNY Law. And I'm here today to talk about the triple helix, or perhaps the quadruple helix, teaching and critical information literacy. I'm very excited to be here. And I wanted to thank Professors Delgado and Stefancic for starting this conversation and generating such wonderful conversations and thoughts. Go ahead and forward this. Okay. So in 1989, when Professors Delgado and Stefancic created the metaphor of the triple helix, they wrote, "We call the situation confronting the lawyer or scholar trying to break free from their constraints the triple helix dilemma." Breaking free is one of the key phrases I take away from that quote. One of the most problematic aspects of the triple helix dilemma are the ways in which those strands really do constrain the mind. And Professors Delgado and Stefancic grappled with how to break free from those constraints in that 1989 article. Since learning and reading about the triple helix, I've been thinking about how to help students begin to break free from those constraints. And in doing so, I've been looking to critical information literacy for guidance. But before going into critical information literacy, I want to talk a little bit more about the triple helix and how I think about the triple helix. One of the things that is confounding about the triple helix is how deeply it obscures human influence. The topic and key number system, classification systems, indexing systems, all of these things, these traditional things, they have this veneer of objectivity and neutrality, but that hides this human bias, human choice, human judgment that goes into making them. And I think about this as being that there are invisible hands that are creating these systems. And if we can make those hands visible, we can begin to confront that human bias. So the question for me is, how do we render visible those invisible hands? You know, those hands that are busy classifying and structuring and presenting that information. How do we help students see those hands so they can start breaking free? I think it's getting a little bit more complicated with this fourth strand, this new strand, that makes this perhaps a quadruple helix, algorithms and artificial intelligence. As professors Delgado and Stefancic presciently wrote in their 2007 article, a computer is good at showing you what is. It cannot show you what might be. So again, with algorithms and AI, we have human-created systems, and we also have invisible hands that are creating these systems and shaping the information and shaping how it's received and perceived by the researcher. Moreover, there's been a lot of research recently about how algorithms tend to replicate the sexism and racism that are in our society. And this term, algorithmic oppression, has been coined by Sophia Imogen-Noble to describe this phenomenon. But the question still remains: how do we make those hands, those invisible hands? How do we see them? These are new invisible hands that are implicated. Now we have programmers and user design professionals and mathematicians all implicated in making the algorithms and AI. So how do we help the students see what they're doing and how they affect what we see? So I'm going to look to, or I've been looking at critical information literacy, which is a type of information literacy that's been developing over the past decade or so, perhaps a little longer. There isn't really one definition of critical information literacy, but it is, I guess we could say that the key thing about it is that it is an information literacy that focuses on the social construction and political dimensions of information. So there are so many ways we can focus on those different, on social construction, political dimensions of information. It can focus on who creates information. It can focus on who controls access to the information. Or in the case of the quadruple helix, who organizes and presents that information. Critical information literacy often uses dialogue, inquiry, and problem posing as tools for the classroom to ask students to reflect on the information. And I've been thinking about how dialogue, inquiry, and problem posing can really help make those invisible hands visible, helps us see those invisible hands in the classroom through a question and answer. So I have just a couple of brief examples of the kinds of inquiry and dialogue that can happen in the classroom to help us look at those strands of the quadruple helix. The first one I have is the traditional topic and key number system, or the digest system, which is that both stands on its own as the digest system, but it's also amplified. It's internal to the algorithms in our legal research systems in Westlaw, in that the algorithms take into account those traditional classification systems. So some questions that I've used in the classroom about the topic and key number system to help them think about it. Who created the West topic and key number system? And what kind of society did they live in? Who's been excluded from the process of creating the taxonomy? How do these categories reflect societal values? And you can, really look through those that very large taxonomy and think about that. And why does the topic and key number system persist? And who owns and controls its existence? So that's just a start. I'm sure there are many more questions that we can all think of that will really help us interrogate that structure. But if it's one of the things that we can talk about when we start talking about the topic and key number system, just as a practical tool. The second example I have is with algorithms. Again, I have very similar questions, but of course they sort of resonate differently when it comes to artificial intelligence. Who creates the algorithms that are baked into our legal research system? And how much does the algorithm affect our search results? Do we even know? Is that something anyone can know? I don't know. But it's good to also see what we don't know. And how might your results reproduce these existing systemic biases in our society, the racism, sexism, and many other biases that we have in our society that have gotten fed into our algorithms. So those are two, again, very brief lists of questions that I've used, and I'm sure there are so many more. But I thought that would be a good way to begin this idea of thinking about how to use inquiry, dialogue, and problem posing through critical information literacy in the classroom. While there are no clear answers, no one has ever been able to get a clear answer and complete clarity out of any of these dialogues for these kinds of questions. I hope that by asking students to reflect on the different strands of the triple, quadruple helix, we can help them see those invisible hands. And then in doing so, help them free their minds. And that is what I have. I'm going to go ahead and stop my share.
Thank you, Yasmin. That's great. Our next speaker is Grace, and I'll let you introduce yourself, Grace.
Hi, everyone. My name is Grace Lowe. I'm a reference librarian at Stanford Law Library, and I'm also going to be sharing my PowerPoint, if you'll just bear with me one moment. There we go. That should be up now. Okay, so again, I would also like to express my thanks to AALS and to the organizers for creating this panel. And it's really an honor to have a chance to share the virtual stage, so to speak, with Professors Delgado and Stefancic and all of the panelists here. So I'm going to be talking about the use of subject headings in the law library and in legal research. And this really refers to basically one of the helices of the triple helix dilemma, which is the Library of Congress subject headings, or LCSH. This, along with West Digest systems and the index to legal periodicals, are the sort of three helices, and reading about how these three legal research tools really work to reinforce each other's biases and limit creativity and innovation in legal research. That was my introduction to how the field of critical legal studies could tie in with librarianship to create this field of critical legal research. So a little bit of background on the Library of Congress subject headings. The LCSH is essentially an indexing system created to organize the Library of Congress's massive collection, but it has been adopted more widely by various other libraries. An indexing system operates a bit like tagging. You identify key subjects that a book is about in order to describe the book and to connect it up with other books about the same topic. Unlike tagging, the LCSH is a controlled vocabulary. So unlike Twitter or Instagram, where you can write anything you want behind a hashtag, this is a set list of accepted terms that is determined by the Library of Congress. This slide here shows an example of how such subject headings get applied specifically for Professors Delgado and Stefancic's book, Critical Race Theory. And you can choose any one of these subject headings: race discrimination, critical legal studies, racism and language, and get a list of other books on the same topic. This system of the Library of Congress subject headings gets used across many, many libraries, including most law libraries. And that means it does have an impact on how legal research is conducted, with how students and lawyers understand these legal concepts, how they get grouped, how they get applied. And that's why it does form one of the helices of the triple helix dilemma. Now, LCSH is well respected and widely used with good reason. It derives a certain amount of authoritativeness from being created by the Library of Congress, which is an official government body. It serves the de facto National Library of the United States. It's meant to index a huge and diverse collection of materials, quite possibly the largest in the world. And the Library of Congress does make an effort to regularly revise its subject headings, to update the terms, to add or remove terms, but it can still be a bit slow and a bit behind the curve, especially on emerging issues and on controversial subjects, which does make it vulnerable to bias. It has a certain amount of baked-in bias in that it's going to favor official US government positions. And furthermore, it wants to create some sense of longevity. LCSH is over 100 years old. Certain things are just outdated and haven't been updated because it's a massive system. And it also wants to sort of avoid having to constantly change its terms, so it may not establish a subject heading for a concept that the library considers transitory or insufficiently well established. And so a prime example of how the slow pace of change creates an issue of bias in LCSH is the controversy surrounding the subject heading illegal aliens. Illegal aliens is a subject heading currently in the LCSH and has been used for several decades. In 2014, some student activists and librarians from Dartmouth petitioned to the Library of Congress to change this term on the basis that it has, especially in recent years, taken on an increasingly pejorative connotation. If you're interested at all, there's a fantastic documentary about this chain of events called Change the Subject, and it's available to stream through Dartmouth Library. So this effort started in 2014, and the Library of Congress initially rejected their proposal, but after some additional work on their own, in March 2016, the library announced that it would, in fact, discontinue that subject heading and instead replace it with the terms non-citizen and unauthorized immigration. However, this sparked immediate political backlash, with various members of Congress calling it Orwellian and political correctness gone mad and all of that. In the end, Congress didn't specifically expressly instruct that the Library of Congress needed to maintain its current language, but instead it issued an instruction that statutory language needs to be a major consideration in determining the subject headings, which basically implied the same thing. As of today, the Library of Congress has not made this change to its subject headings, nor has it made any other statement on this matter since its March 2016 announcement that the subject heading would be replaced. Instead, the issue has just been kind of frozen in limbo for the last 4 years. Now, the considerations made by the Library of Congress in determining what to do or what not to do and being hesitant to change are really also echoed in legal research tools more generally. For instance, this prioritization of legal or statutory language, even when popular usage and common understanding of these words has kind of evolved and moved on, and also concerns about political backlash or controversy. So the Library of Congress subject headings might seem a bit niche or quaint or even kind of an antiquated system, given that it is over 100 years old and that it's historically been used for print materials, but it is still being used in universities and law schools and law libraries everywhere. And it still has an influence on how people do their research, and it's unlikely to go away anytime soon, especially with how new search tools and technology is developing. As Yasmin noted in her presentation, technology, rather than solving the triple helix dilemma, has instead exacerbated it into something of a quadruple helix dilemma. So new systems often still reuse and recycle old systems and old data, even if you can't tell right away. For example, if you, instead of going to a library, you go to Amazon Books to look up information about books, you're not going to see the Library of Congress subject headings used on an Amazon page. However, if you look to the source code on an Amazon Books page, you may well find that Library of Congress subject headings get used as metadata keywords, which impacts how search engines read the site and search the site. On a broader level, new search engines and systems often make the same kinds of philosophical mistakes, even if they don't directly use the old data. as noted in Sophia Noble's book, Algorithms of Oppression. In the case of search engines, not unlike cataloging systems, the social context and histories of exploitation or objectification are not taken into explicit consideration. Rather, they are disavowed. Old cataloging and bibliometric practices are brought into the modern system's design. What's more, as noted also in Yasmin's previous presentation, is that there's a real issue with lack of transparency in new search tools. With older systems, I mean, it's also hard to trace back. You still have the invisible hands issue, but at least, for instance, with the Library of Congress subject headings, a group of undergrads and librarians were able to track the path and figure out how a subject heading comes into being, how it can be changed, even if the process is incredibly difficult and politically fraught. With black box algorithms, that process becomes so much harder. Matthew Reitsma is a librarian who writes a lot about library technology, and his book, Mass by Trust, talks about this trend in library technology to try and emulate the use of a Google search box. There's a habit of trying to emulate that ease with which a single search box can be used to pull resources from a diverse range of sources and a diverse range of materials, but it often ends up being inaccurate and biased, and their results are always a little bit off. And it's not easy to figure out why or how to fix it, simply because that interface has been so simplified. This lack of transparency really puts a burden on users to become more savvy and on intermediaries like instructors and librarians to understand how these systems work, what are the possible flaws, and why these flaws exist, and really requires us to be more thoughtful and imaginative about how we engage with information access systems and avoid taking their authoritativeness, neutrality, and accuracy for granted. And this is why it's so important to apply critical legal research and critical information literacy to examine past and present legal research tools. Thank you very much, everyone. I'm going to stop my share.
Thank you, Grace. Next, we have Julie Krishnaswamy.
Hello, I'm Julie Krishnaswamy. I'm the head of research instruction at Yale Law School and a lecturer in legal research. Thank you, Professors Delgado and Stefancic, for all of your inspirational work. And thank you, Nicholas, for putting this panel together. I'm excited to be here today to share my thoughts along with these other influential scholars. My article, Critical Information Theory, A New Foundation for Teaching Regulatory Research, which appeared in the collection, The Bolder Statements on Legal Research Education, The Intersection of Intellectual and Practical Skills, published by Susan Nevelow-Mart, attempted to offer a pathway to break away from categorical thinking in legal research instruction. It was also an opportunity to revisit and offer a strategy to address the concerns presented by Delgado and Stefancic in their 1989 essay, Why Do We Tell the Same Stories? And again, in their 2007 follow-up, Why Do We Ask the Same Questions? In my article, I drew on the work of Delgado and Stefancic and critical information theory using regulatory research as an exemplar in my article. Regulatory research taught from the perspective of critical information theory is a pathway for the consideration of 1, regulatory transparency, 2, agency accountability, 3, due process and fundamental fairness in the context of agency adjudication and rulemaking, 4, private-public partnerships, 5, expertise and discretion. I'm not going to talk about all of these aspects today. Underlying these questions, however, are concerns about how government works, which entities have power, and which entities are privileged in this system. Put simply, who and what interests are at play. Delgado and Stefancic challenge us to ask questions without relying on the categories that have been predetermined by legal doctrines, the legal academy, and the commercial legal publishing enterprise. My answer was found in regulatory research. First, I drew from critical information studies, which at the time of my article was an emerging discipline that considered the ways in which culture and information are regulated. Critical information theory calls attention to culture and specifically to documents, sources, and materials, as well as the cost of such materials. This theory prompts users to ask questions about access and costs, but also whether the structures for using information have a chilling effect on their users. Regulatory research can be taught outside the gates of the commercial legal publishing enterprise by relying on government materials and open access materials, many of which come from fields other than the law. Using these materials allows students to consider how members outside of the legal academy access legal information as well as non-legal information, and how that information can be used to construct arguments to advocate for change. Frankly, Westlaw and Lexis have dominated legal research, and that needs to stop. As law librarians, we need to stop relying on them so heavily, and the onus is on us as teachers to expose students to research strategies outside of Lexis and Westlaw, namely government and open access sources. Working outside of Lexis and Westlaw gives students practice finding, analyzing, and evaluating other forms of information, doing exactly what Yasmin advised. Using government materials in this way also helps us to consider the successes and failures of the e-government initiative in the United States. Nearly all agencies engage in e-rulemaking, which is the use of digital technologies in the development and implementation of regulations. E-rulemaking exists not only to leverage technologies, streamline process, and to increase efficiency, but also to increase the public's awareness and involvement in rulemaking. To be sure, transparency and rulemaking has increased with the advent of digital materials and electronic research systems, but that increase has been uneven. E-rulemaking provides an appropriate context for thinking about publication, distribution, and transparency. In teaching regulatory research, I will often focus on the formation of an agency and ask students to research that very question. This research not only involves finding and understanding the enabling legislation and the power of the agency, as well as the crises that may have created the agency or the problems that the agency was set out, problems that the agency was created to remedy. But it also gives students the opportunity to see that there are unforeseen outcomes to legal actions, even when actors have the best intentions. It is my hope that this is one of the questions that breaks students away from predetermined ideas about how to research and which sources to synthesize, and the stories that we tell about the law. Furthermore, I hope to activate students' imagination and to allow them to ask, what could this agency do? What is it empowered to do to improve the lives of individuals or the health of individuals or the environment? Critical information theory pulls from multiple disciplines. In regulatory research, looking outside of the legal academy is especially helpful. Students can draw on historical materials, news, political science, statistics, data, health, science, among other fields, including personal narratives. Frequently, one regulatory issue will contain aspects of each and every academic field and discipline, and multiple narratives. Again, this is an opportunity to release students from the categorical thinking caused by the legal academy and the beloved legal research systems. As Delgado and Stefancic have observed, the legal academy generally, and legal research specifically, funnels students into one category or one discipline or one area of black letter law. Indeed, students often collapse questions into one key word. or one question. Yet administrative law research demands that students couple and combine disciplines and categories. Most, if not all, regulatory issues overlap in multiple areas. For instance, environmental concerns usually overlap with health concerns, housing concerns frequently overlap with small business concerns, or transportation concerns overlap with employment concerns. Civil rights concerns frequently overlap with equality concerns. Likewise, there are overlapping jurisdictions to dig into. Looking outside of one idea or one category gives students access to what and which groups are on the periphery. The challenge here for students and legal research teachers is the massive volume of information, as well as the students' tendencies to graze through information. In teaching students the basics of regulatory research, they must learn how to find and read rules in their various forms. This is important for basic searching, but it's also important as a way to get students to consider the context in which rules are drafted. For instance, I'd like to ask students to consider which groups were involved in the rulemaking process, whose voices were considered, who had access to the materials that the agency relied on in making its determination. In other words, who were the stakeholders sitting around the regulatory table? Similarly, I'd like to explore what types of materials would be used for commenting on behalf of a certain individual or group harmed or implicated by the regulation. To conclude, this is my attempt, joined by others on the panel, to move our field, the field of law librarianship, in the direction of critical legal research. Delgado and Stefancic observed in their 2007 article, "The act of imagination requires stepping back and pondering history, politics. To practice thinking outside of the box, it requires a conceptual advance that sees old materials in a new light." Thank you for inviting me today.
Thank you, Julie. That's great. Now we're going to hear from Nicholas.
Hello. Oh, great. My name is Nicholas Mignonelli. I'm a former reference librarian and lecturer in law at the University of Miami School of Law, and soon to be a research librarian at Yale Law School. The title of my comments today are Richard Delgado and Jean Stefancic, Prophets for an Algorithmic Age. The gift of prophecy when practiced by earthly oracles, wrote the late Professor Derek Bell, entails a risky willingness to predict the future events based on an examination of the present using the insight provided by an evaluation of the past. I would add that there are also times when commentators unintentionally act as prophets, when their insights about the contours of the present are so penetrating that they cut to the very structures that have shaped it. This, I believe, is certainly true of Professors Delgado and Stefancic and their theory of the triple helix dilemma. Much can, should, and has been said of the far-reaching implications of their 1989 article, but what has always struck me is the prescience of certain comments they made in their 2007 article in Law Library Journal, Why Do We Ask the Same Questions? The Triple Helix Dilemma Revisited. In this sequel to their 1989 article, Professors Delgado and Stefancic write, "Internet searching presents a different obstacle. Most material on the internet comes arranged in order of frequency of use. Websites and homepages that previous users have visited many times appear high on the page. Less used ones further down. This popularity contest approach to listing information builds in a structural bias in favor of commonplace items that have found wide use. Heretical or new ideas that are just beginning to be noticed may easily escape the attention of a busy searcher." The crowdsourcing that they were describing, and that Ron Wheeler also described in his 2011 article, was of course a forerunner of what we have come to know as artificial intelligence, specifically machine learning, the form of AI that employs algorithms that discern patterns in data and infer rules that on their own. The rise of AI and the threat algorithmic bias poses to the interests of the marginalized in our society, to say nothing of human freedom itself, reads like a chronicle ripped from the pages of one of Professor Bell's law review articles. A small group of primarily upper class, primarily white, and primarily male technologists, educated at America's elite universities, discover a way to use complex mathematical formulas to make life more convenient. That is to say, in the 1950s, consumerist sense of automated, for everyone, who matters, promising to save governments and corporations billions of dollars in the process. The adoption of this technology does, of course, necessitate a trade-off of sorts. In order to achieve the efficiency and cost savings so valued by the dominant forces in our society, the hope of marginalized people for reform and systemic change must be sacrificed. You see, by using past user data as its basis, this technology threatens to entrench forever, or at least for the foreseeable future, the inequities that lie at the heart of our society. Soon this technology finds its way into law offices and courtrooms when it begins to power legal research and law practice technologies. It seems to me that Professors Delgado and Stefancic not only foresaw this phenomenon, but provided us with the tools necessary to contend with it. In their 1989 article, they invite readers to look to divergent individuals. That is to say, individuals whose life experiences have differed markedly from those of our contemporaries, because their ideas offer the possibility of legal transformation and growth. This is precisely what we must do as we contemplate the ways in which AI-powered legal research and law practice technologies threaten to entrench the biases of society's dominant interests. Several feminist and critical scholars writing outside the legal academy have begun the difficult work of thinking about and criticizing AI by looking from the bottom. These scholars include Ruha Benjamin, author of Race After Technology, Abolitionist Tools for the New Jim Crow; Sophia Noble, author of Algorithms of Oppression; Virginia Eubanks, author of Automating Inequality, How High-Tech Tools Profile, Police, and Punish the Poor; and Kathy O'Neill, author of Weapons of Mass Destruction. Unfortunately, these works have yet to gain traction within the legal academy and within law librarianship. Yet if we are to take seriously the threat AI-powered legal research and law practice technologies pose to the marginalized, we must begin reading these works and thinking about how they relate to our field. Thank you so much.
Thank you, Nicholas. That was great. So now it's time for our special guests, our honorees, to offer their thoughts on what we've heard thus far. I feel like before you speak, we should give you a cyber round of applause or something. Can we do that?
No, we want to give it to you.
As you'll see.
Yeah.
Hey, in recent weeks, a familiar scene has been playing itself out in universities and colleges across the country. Law faculty members everywhere have been requesting and often receiving permission to teach their classes remotely on account of their age, medical condition, or status as caretakers. Those who obtain such accommodation often then receive a questionnaire from the central administration a few days later, asking for details of how they plan to teach their classes and use their time. Such a questionnaire may begin by asking if the professor has received training in Zoom or some other remote teaching modality. It may ask what percentage of the professor's instruction will be synchronous and how much will be asynchronous. What provisions will a professor make for small group or individual learning experiences and so on? Logical enough. But then the form might easily go on to ask questions about how the professor will produce measurables or help advance student identity formation and other matters that seem to have little application to law school teaching. A typical faculty member, I'm sure I can tell you this happened to me, could very well try to put themselves in the mind of an administrator, the one who made up the questionnaire, someone who knows little about law school teaching, and then might try to answer the questions with that person's bureaucratic needs in mind. That way, the professor may reason, I'm not going to have to change anything I do. I just describe it in admin speak, full of words like targets, feedback, professional development, and measurables, and so on. If I don't know the answer, I'll just guess or make one up. Always aware that what I'm trying to do is trying to fit my reality, my teaching and goals into someone else's categories of things that are, for some reason, reasons that I may not be able to fathom, important to the central administrator. This is in some respects like the dilemma that prompted Jean and me to write many years ago, Why Do We Tell the Same Stories? Law Reform, Critical Librarianship, and the Triple Helix Dilemma. In it, we considered the predicament of a progressively minded scholar or lawyer seeking a new analysis or solution to an old problem. Say a group of renters vying to resist a landlord who wants to throw them out in order to build a high-rise condo on the property. The commercial research services lead to solutions that are unlikely to work and may even lack terms to describe the renter's dilemma in ways that make sense to them. Terms like gentrification, renters' strike, housing development's resistance to may not yet have found a place in either the search material or the searcher's mindset. In our article, we gave the example of a Black woman who suffers racial discrimination at work, but encounters no legal theory that addresses her dilemma in specific terms. The article led to a considerable body of scholarship in information science circles, much of which taught us a lot more than we taught the authors, many of whom are on this panel today, for which we're very grateful. Nicholas Stump, for example, taught us how one can use innovative sources and critical tools to combat environmental destruction stemming from the practice of mountaintop removal in West Virginia. Yasmin Soker Harker enlightened us about informational literacy in the new ACRL framework that replaces the former standards for learners eager to advance social reform. Nicholas Mignanelli reminded us how innovators like Mary Jo Frug, Robert Bearings, Stephen Barkin, and Jill Ann Farmer showed how to escape being locked into place, especially during an age of artificial intelligence. Grace Lowe demonstrated how the Library of Congress is reforming itself, albeit very slowly, using the subject heading Illegal Aliens as an example. Julie Krishnaswamy showed the need for new research pedagogy to include critical information theory so that learners can conduct legal research with awareness of the weaknesses and limitations of the tools that they're using. She also pointed out how this is particularly critical when the problems they're researching concern vulnerable populations or very old paradigms that are impeding change. And a host of other writers like Ruha Benjamin and Kathy O'Neill have urged us to consider how profit-minded corporations like Google and Microsoft develop algorithms to increase their hegemony and control over the market for information and search tools.
An event in the national news reminded us once again that debates about classification and categories are not only about convenience. How you classify something invites others to adopt one mental pathway or another. And often the proposed classification accompanies a power move of some kind, one that is even more effective if the classification system seems or comes to seem obvious and ordinary through use and repetition. Once this happens, a user, such as a first-year law student, does things the same way time after time as a matter of course, because this is just how it is done. Just like the professor who fills out that long questionnaire from the central administration about his or her plans for teaching online next semester. We offer two examples of this approach in action, one having to do with the Mexican-American community in Tucson, Arizona, another in the form of Donald Trump's executive order banning critical race theory in federal contracting or employment. And we end by noting how the mob that invaded the Capitol this week actually believed that they were performing patriotism and love of country. It's a commonplace that words and concepts can have more than one meaning. Probable cause can mean one thing to the public defender and quite something else to the prosecutor. But the same is true as well of broad legal theories or points of view. They can take on more than one meaning depending on one's perspective. This is, of course, not to say that they are all equally worthy. Darwin's theory of evolution is much superior to creationism, although that superiority was not obvious at first, at least to many ecclesiastics. This was true in Tucson, too, at least at first. As you may know, a curricular controversy began when some young school teachers trained in ethnic studies began teaching that subject to kids in a racially mixed high school in downtown Tucson. The program began under a federal consent decree and then took off under its own steam. The kids, mostly from poor immigrant families, learned about the great civilizations of Mesoamerica. They learned about Cesar Chavez, Martin Luther King, and about the civil rights movement. They read books by Howard Zinn, Sandra Cisneros, Paulo Freire, and critical race theorists. All this created quite a stir. The kids grew excited to discuss what they had learned with their parents at home. Many decided they wanted to become novelists, doctors, or lawyers like the ones they'd been learning about. The dropout rate among Mexican-American school kids in that district had been 50%. Now, nearly all of them were graduating, and some were going to college. But word reached the legislators in the Capitol, who were not at all impressed. They decided the whole thing was un-American and passed a 4-part law forbidding courses like it. The law punished any school district that failed to comply by threatening to withhold 10% of its budget. The community was up in arms and filed suit, but they lost because the Secretary of Education had taken the precaution of obtaining a ruling from an administrative law judge that the program was in violation of the statute. For good measure, the judge even banned 7 of the textbooks, including ones by Paulo Freire, Howard Zinn, Rodolfo Acuna, The Two of Us, and a play by William Shakespeare. The case went up and down to the Ninth Circuit and was retried in front of the same district court judge that had struck down the program 18 months earlier. This time, he declared the statute unconstitutional. The district reinstated the program in a watered-down form, but in the meantime, many of the original brilliant teachers had left for greener pastures. You could see all of this as a battle of warring paradigms, or, if you are an information scientist, of legal categorization. The program was either un-American or a breath of fresh air, depending on the interpretation you placed on it. You could evaluate the program solely under the 4 headings of the Arizona statute: treasonous, un-American, full of resentment toward white people, and so on. Or you could see it as something legitimate and entirely helpful to an oppressed group. You also might consider 2 ways an indexer might classify the case when they get around to doing it: school curricula, un-American, or educational discrimination, remedies for.
You could also see much the same playing out in connection with the second example, Trump's order banning critical race theory in his hour-long speech at the National Archives Museum that preceded it a few weeks ago. We have the 2 documents right here. If you look them up, you would notice how they contain a number of familiar categories, but carrying quite different value judgments or valences from the ones those categories occupy in the school of scholarship known as critical race theory. For example, you would see how critical race theory's analysis of white privilege becomes, in Trump's eyes, evidence of hatred toward whites. Affirmative action and the study of implicit bias emerge as discrimination, but again, against whites, since it supposedly deems all of them racist. The critique of colorblindness, a mainstay of critical race thought, emerges as insisting on a thumb on the scale in favor of any applicant of color to any position at all. And our teaching about systemic racism emerged as a tool for liberal brainwashing of innocent undergraduates. The critique of hate speech come across as an attack on the mighty First Amendment. Earlier, detractors even took issue with Du Bois's notion of double consciousness, seeing it as evidence that minorities are obsessed with race and see discrimination everywhere. The same is true of microaggressions, which appear on their chart as a neurotic fixation on small affronts. It's a bit like 2 indexing systems, one reflecting the point of view from inside, the other a harsher view from the outside, full of fault-finding and disdain. And if you're unfamiliar with critical race theory, the negative version has a superficial plausibility. Like a drawing by Max Escher, it invites you to perform a gestalt shift. In one of that artist's best-known drawings, a flock of birds flying to the right looks like a school of fish swimming to the left, depending on how you look at it. So when Trump and his speechwriter composed their two broadsides against critical race theory, they were writing against a background of many similar flips or inversions that a conservative audience has heard about or discussed dozens of times with their friends. And once a person takes that point of view, one can take practically any entry in a bibliography of critical race writing and show how each item corresponds to a different and antagonistic heading in a conservative mindset and belief. A detractor steeped in Fox News might note, for example, that some critical race theorists find fault with capitalism. This is true, many do. But an antagonistic reinterpretation might easily charge that the entire school of thought is based on Marxism, ignoring that a lot of the most formative texts barely mention the term. As with Escher's drawing, preconceptions shape what the observer sees. Consciously or unconsciously, Trump drew on them. Conservative websites and talk radio had paved the way, priming their followers to see critical race theory a certain way. That's why the executive order struck most of the followers. It's true and deserved.
You might even go back further in time to a period just a few years earlier when critical race theory came under attack in the law reviews. Conservative legal writers performed many of the same maneuvers, standing things on their heads. I'm going to leave out all the examples so that we could get finished in time. All these scholars attached unfamiliar and harsh interpretations to the new scholarship, interpretations that took on the aura of truth to people already disposed that way. They liked the grid it offered, even though it bore an eerie resemblance to our own, except that everything took on a different and antagonistic interpretation or valence. All this is a little hard to fathom if you basically agree with a new theory of or concept like critical race theory, as many of you might. But railing at the way a critic categorizes your favorite area won't help you if the critic has tucked you away firmly in a category that is meaningful to him or her and not to you. That critic then will read and interpret everything in hostile fashion because she starts with a different desire or orientation in mind. In short, we think that desire comes first and is prior to thought and cognition. We first want something, then we look for terms, words, concepts, and thought paths that will enable us to find it. Reference librarians know this only too well. One told us that they can almost tell from a patron's facial expression and demeanor what kind of search they will want help with. A desire-based theory helps us understand how commercial research systems improve a searcher's access to cases and authority, but mainly ones that will fortify and defend something the searcher agrees with, often a mainstay of Western corporate capitalism, as many of you have pointed out. These systems help the researcher perform law, which is why they consulted the search tools in the first place, but they also make it hard to find anti-law.
Western law and capital, we think, are essentially the same thing, and a thing cannot reform itself, at least not easily. Duncan Kennedy's article on Blackstone's commentaries makes much the same point. To hope that index searching will enable you to carry out law reform is to commit a type of category mistake. It's not the kind of thing that can do this, at least not without considerable effort. As a conservative columnist, Russell Duthert, put it recently in connection with the election results, quote, "A strong belief spurs people to go out in search of evidence. A lot of so-called disinformation is collected and circulated sincerely rather than cynically, and thereafter the power to change beliefs is relatively limited." We agree. Once a reader becomes ill-disposed toward a school of thought, she's apt to declare evidence confirming it not evidence at all, much less dignify it with a category or search term of its own. Thereafter, you really cannot easily look it up, particularly if you're in a hurry and eager to find that missing site or reference that will enable you to finish an assignment on time. Unless, that is, you have a little help from a friend in the library, like the ones on this panel, and others who've been writing about how to recognize the influence of conventional research tools and keep looking for something better. This may entail blasting the categories, turning them on their side, or consulting someone whose experience has been radically different from yours. Panels like this one and the scholarship of the people appearing today are, we think, good places to start. And on a broader scale, they can help us understand how thousands of excited white people wearing red hats actually thought they were acting heroically when they trashed a building that is the symbol and seat of American democracy. Back to you, Ron.
I was enraptured and lost track of the fact that I am in front of all of you. So thank you very much for your insights and your insightful comments. We would very much like to take questions from the audience. I am going to see if I can manage to open my chat window and see those questions. Looks like I am right there. But I have a couple of questions of my own. And since I am in front of you and I have the power, why don't we start with, let's see. So, I was intrigued by all of your comments, but Julie, one of your comments you talked about categorical thinking and I can't read my writing here. My question is, what about the categorical thinking and the interests, the political interests or self-interests served by the government and government sources and how they categorize information? Any thoughts from any of the panelists?
Trump is a government source, I guess, for another week or so. I don't much like his categorization system.
That's your answer.
Absolutely.
Yeah, I agree. Government sources have their own way of categorizing information, and it often mirrors the legal classification. So I think students can use the government categories as a model, but government sources are kind of decentralized and detached from the traditional legal classification and indexing system. So I think students have to work harder to find them. And also materials, different types of materials are categorized in different ways. Take, for example, an agency guidance document. An agency guidance document can be referred to in half a dozen terms and ways. And I think that's a really good exercise for students to think about how might this material be categorized. I'm also thinking the question that seems very simple on the surface, what is an agency? But just that question, again, involves a category that students think they know. But once you start taking apart that question, is a commission an agency? Is a board an agency, et cetera? Those categories become very, very fuzzy and very squishy. And I think that's where the thinking happens, and that's where the fun research happens. But I'm going to continue to think about this. Ron, thanks for the question.
Thank you. That was a very, very exquisite answer. I just saw a question and it went away from me. Let's see if I can find it. How about this? To Delgado and Stefancic, are you optimistic about the ability for your concerns to be implemented? Are there dark days ahead? Do you see a light at the end of the tunnel? Question mark.
Jean is optimistic. I'm not. So I guess our answers differ. I think that information is so valuable that in a corporate capitalist country like ours, you have to work really hard to wrest some of it back, some control of it back, and the system will not reward you when you do it. The students may not particularly like you. They may ask questions like, "How's this going to help me get a job? What's the real site that I'm looking for, professor?" So yeah, it's really hard. Jean, you're more optimistic, aren't you?
I'm optimistic, but in the long run, I've been asked to talk about the future of critical race theory at the American Sociological Association in August. So I think about this a lot, and when I think back, this was the first article Richard and I wrote together way back in the late 80s. And it's only been, well, I can't say only. I guess critical race theory has been there all along. But to me, it's like putting a drop of ink in a saucer of water. It just spreads. It spreads, it diffuses out into the whole saucer of water. First, it makes a big splash. People say, "What is that? I don't like it. Look how it's messing up my saucer of water." And then gradually, that saucer of water becomes pale blue, pale purple, whatever, and it permeates the culture. And I think that that's what's happening right now, but it's taken a long, long time. And the work that you're doing probably seems radical to most law librarians. I remember being a law librarian, being kind of on the edge all the time. People wondering, well, why are you doing that? But look what's happening in critical race theory. When we teach our practicum once a year in the fall, we always get an amazing crop of students. It's not a big class, like a seminar. And it's what keeps us going. We could be retired. We could be, doing whatever. Of course, not during the pandemic. But
my kids think I am retired because to them it seems like such an easy job.
Yeah. But we were, I don't know. I get so much hope from seeing the young people come through. I don't know what's coming after them. But the past 4 years or so, we've seen class after class of optimistic, hopeful students who just keep charging ahead. They make these plans for reforming law that they're going to implement after they graduate, and they really do believe it. So I am optimistic in that sense. But I do wonder about you, about how things are going to be for you as a group of critical legal research librarians, because we know that in the early days of critical race theory, this was really tough. The first 20 years or so, there was so much pushback, and now it's become sort of part of the discourse. People don't even realize where the words they're using have come from. There's still people who are skeptical and don't like it at all. But hey, you want to have a legitimate argument, a legitimate discussion, fine, do it. But it won't be easy. It won't be easy. But I think it's doable, because the culture, if we have a chance to get past the pandemic and restore some order in our country at least, we will have a chance. It's just inevitable in my eye.
I love your perspective and I love your optimism. I fear that it is past time and we need to depart. But can we please give a huge cyber round of applause to our special guests, Richard Delgado and Jean Stefancic. It has been such an honor and such a pleasure. I'm almost in tears, and you guys know I tear up really quickly. So I better sign off.
Okay.
Thank you so much.
Thank you. And I think we should have roundtables often and keep together, sharing your ideas and helping each other.
Yeah, everywhere. AALL, every opportunity you get. You're a great group. It's a lot of fun listening to you and interacting with you.
And keep in touch with us, please.
Oh, yes, definitely. You'll be getting emails from me for sure.
Okay, let me point out one thing since we are concerned about details. My name, Stefancic. You won't find many names like this. Unfortunately, I was not born with it, but I have it. And so this name is pronounced Stefancic.
Stefancic.
Got it? Stefancic.
Stefancic.
Not that I care. Doesn't matter to me. But databases will pick it up if you spell it wrong.
Thank you for that.
It's something only you all can understand.
That's right.
A little bit of a debate about how to pronounce it.
That's right.
Yeah.
She has 2,000 sites in some Laureate database. But if you check misspellings like Stephancic or Stefanic, you get many more.
Yeah.
Okay.
You're really
okay. Well, we better get out of this room so somebody else.
Okay. Thank you again. Thank you so much.
Thank
Ron?
you.
Yes.
We learned so much about you. Really, truly.
I just wanted to mention briefly that the of this panel are going to be published in the Boston University Law Review online this spring. So look out for that. And if you're interested in learning more about all the amazing comments that were made today, they will be in print later this spring.
Thank you. Thank you for that, Nicholas. He has such a level head and gets out the information, and I'm all over the place. So thank you. Thank you all to all of the panelists. You were all great. And thank you, all of the listeners, watchers for participating.